Hi, welcome. I'm so glad you're here. Um, I have done a ton of business law over the 26 years I've been practicing law, and I absolutely love it. I love teaching this class. I love having you in the class. Um, and I even wrote the book, and for a legal book, it's much cheaper than most legal books because I wanted to make it more affordable. Could you get away without the book? It would be hard if you absolutely, completely, totally focused on the PowerPoints and the audios, maybe, but honestly, people do the best with the book as well. Business law, like I told you in your syllabus and elsewhere in Canvas, you can Google it and get 50 different answers because there's 50 different states. So we want to focus more in California, and that's what this book does. So let's start with a very basic building block of business law, and that's agency. All right, I'll let you read the chapter objectives on your own. It's not meant to be rereading the PowerPoint. It's me meaning to point things out that you need to study for the final and for your questions. Okay, so everything in corporate law or business law builds off of agency. And this is because we're talking about somebody working on behalf of another, okay? And this doesn't always have to be for pay, so it doesn't have to always be an employee-employer relationship. But even if there's not pay, the person working on behalf of another, the agent, can cause the principal to be liable for different things. So in law, that's like one of our biggest concerns is liability, at least in civil law. In criminal, of course, it would be guilt or innocence, but in civil, it's liability. So we're always looking to see if there's some way to get to the bigger pockets. So for example, if you go to Starbucks and the barista spills coffee on you, can you sue Starbucks? Because the barista doesn't make nearly as much money as Starbucks does. And agency, principal agency says yes, you can because the barista works on behalf of Starbucks. Okay, so a great example of a free principal agency relationship for most people is if they have elderly parents and they agree to be like their power of attorney for their parent, a medical health care decision maker on behalf of their parent. That's an example of a free principal agency relationship where the agent typically doesn't get paid, the child doesn't get paid for doing that on behalf of the parent. Okay, so in order to have a valid principal agency relationship, the principal can't be mentally ill and they cannot be under the age of 18. Also, the purpose for this agency-principal relationship has to be a valid purpose. It can't be a contract for murder. All right, so what are some of the agent's abilities to get things done? It depends on whether it's implied, express, or parent. And so implied is by the behavior of the parties, it looks like somebody is giving someone the right to act for them. So, I mean, again, if you go to Nordstrom's and you buy something, you assume that the salesperson has the authority to work on behalf of Nordstrom's because they're standing behind the counter. Express would be words, either written or oral, that actually state that somebody has the ability to act on behalf of another. So that medical health care directive would be express. And then a parent, something the principal does makes it look like there's an agency relationship. And it's very, very similar to implied. But sometimes it's not as obvious as somebody standing behind a counter. It could be For example, the principal saying, "Hey, can Joe help you?" And the principal did something to make it look like Joe works for the principal. All right, ratified authority is after the fact. You did something, the principal liked it, they said good job after you did it. So if you were a paralegal at a law firm and you went and ordered office supplies and the attorney said good job. Estoppel is based on a fairness argument. And so sometimes, even though you as a paralegal might not have the authority to order, for example, $5,000 worth of office supplies, if you ordered it from a really small company and the law firm was huge, then the judge might say, well, the law firm has to pay the $5,000. Okay, so what are some of the duties that these two people owe each other? An agent has to do the work as fast as possible. They have to notify the principal of important or material information. They are not supposed to compete against the principal, and they're not supposed to represent somebody else whose interests would not align with their principal or employers. They also have to keep track of the spending that they make on behalf of the principal as well. So what does the principal have to do to the agent then? They have to pay if it's not a free agency. They have to reimburse for costs that the agent incurs in the course and scope of doing their job. They have to pay the lawsuits if the agent gets sued because the agent was working on behalf of the principal, going back to that Starbucks example. And they're supposed to cooperate so that the agent can get their job done as best as possible. Okay, so liability. It's also known as vicarious liability. Starbucks is vicariously liable through the barista. And it makes sense because the barista wouldn't be there and working if Starbucks didn't ask them to. Alright, then we have this Warner versus Southwest Desert Images case, and it is a national case. It's out of Arizona, but it does apply in California. Very similarly, we have a very similar rule here. And it was basically a company hired a weed spraying company and didn't want to be held liable for things that happened because of what the weed company did. But they hired them, so they were responsible. How do we end an agency relationship? It can be an agreed upon thing. It can be after a certain amount of time has passed. After a goal is performed. It can basically be bargained for ahead of time or mutually agreed typically upon afterward.